and leave the rest to my colleague Esther Ngawa. Whether the President can initiate changes, stroke amendments to the Constitution, and whether a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 of the Constitution, or through a popular initiative under Article 257 of the Constitution. Let me answer that question with a lot of simplicity, and the simplicity is derived from the nature of the Republic under the Constitution. Now, under Article 1, the sovereignty of the people has a trichotomy of Parliament, which is the legislative arm of government. Then we have the national executive, which is the executive arm of government, and we proceed to the judiciary. What is key to us are two, and we'll find this in Article 94. What is the role of Parliament? The role of Parliament is set out under Article 94 thus: the legislative authority of the Republic is derived from the people and at the national level is vested and exercised by Parliament. You proceed to item 3. Parliaments may consider and pass amendments to this Constitution. Pass amendments to this Constitution, not alter. And for this purpose, I must emphasize, the word alter appeared in the 1963 Constitution. It appeared in the 1969 Constitution. It has disappeared in the 2010 Constitution. Now, compare that with the power given to the President under Article 131. The President, B, exercises the executive authority of the Republic. 2A, the President shall respect, uphold, and safeguard the Constitution. Nowhere in the Constitution will you find any indication of the power to initiate amendments on the part of the President. It's nowhere. And if we may go back to Professor Nobweze, he has made it quite clear that the moment the constituent power has been exercised and the Constitution has been birthed, the individuals in office must exercise the power given to them under that Constitution. Should they seek to alter, they must go back to the people, and they must do that through the 4 sequential steps. The President cannot be President and at the same time be the people. He can't. And if any clarity is required on that issue, we go back to what Justice Professor Wolfgang said, and you'll find this at page 172 of his book. Its goal, the goal of the constituent power, was to counter the king's sovereign powers grounded in law and tradition, and the institutions of the monarch with the original and unbounded political decision-making power of the nation as the force that brings forth the Constitution. Let me simplify this thing. What you're being asked to do by answering this question in the negative is this: to constitute Kenya into a monarchy, or to constitute Kenya into an oligarchy. Kenya is the democracy. It cannot be done. Let me close that argument with an extract from Professor Nobweze, who demystifies that which my colleagues here want to complicate. Nobweze has dedicated an entire chapter on the power of the President and the limitations to that power. If I may take you back to volume 2, and this one is titled "The Office of the President." And the operative extract will be found at page 482. And this is very important, 482. Aside from his legal immunity from suit and from insult, you cannot insult the president. If you think you are equal to the president, just insult him. You will see what will happen to you. Equality is hardly apt to describe the social relations of an African president. Inequality is a necessary feature of the African society. And then he closes by this depiction, which you'll find at page 483. Splendor is indeed part of the social preeminence of African presidents. You'll not find them riding a bicycle like the French president, Macron. You'll not find them eating a burger like the American president, Obama. No. Personifying the state, writes author Lewis, they dress themselves in uniforms, build themselves palaces, bring all traffic to a standstill when they drive, hold fancy parades, and generally demand to be treated like Egyptian pharaohs. Can I bring the traffic in Nairobi to a standstill? Can I build a palace for myself? Can I demand to be treated like an Egyptian pharaoh? No. And with that, a conclusion must be made. If the president is immune, if the president is supposed to protect the Constitution, the president has no role either in the popular initiative or in the parliamentary initiative by way of initiation. He can't. It must be left to the people through the constituent power, or it must be given to the people's representative, the constituted power, which is Parliament. Hence, the clarity in those two initiation processes. If there is anything that I have not said, I will answer it in the question, should any be asked. There is something that I must speak about. Veiled threats have been given to the court that you must not interfere with what the president has done, because the president gets information that is not available. The president knows who are the enemies of state. Look, if the president decides that Nelson Harvey is the enemy of state, and I'm disappeared, I'm abducted, and these things happen daily, we can't question that? No. The president is not the king. The president of Kenya is not a pharaoh. The president is a servant of the people of Kenya. He exercises delegate executive power, and he must be brought to check if he veers off. And fundamental to that premise is this: the president cannot say from one side of his mouth that I'm an ordinary citizen entitled, just like Wangare, Omondi, and Wafula, to initiate a popular initiative towards constitutional amendment, and at the same time say, no, I'm immune from everything, including a transgression of the Constitution. Yesterday, Chief Justice Emeritus, responding to the comments on Twitter that there is maximum security at the Supreme Court, said this: why can't this security be used towards the enforcement of court orders? My ladies and my lords, let me be frank to you. What is being prepared is synonymous to the 1985 palace siege of the Supreme Court in Bogota. That is how it started. If we can't get this, we must threaten you with this. You must not succumb to the threat, which is a veiled threat, that behold, here you are enjoying immunity as judges. Why are you not giving me similar immunity to do that which I must do? For the people of Kenya, exercise the judicial authority delegated to you without fear or favor. And here comes the dirge by Emperor Haile Selassie. You're better off dying standing than living kneeling. Do not be forced to kneel to the caprice and the oppression of those who find the Constitution as an inconvenience. I urge this court to dismiss the appeals by the first and second appellants, and to some extent consider that part of the third appellant's appeal that is in consonance with the general framework of our argument from the High Court to the Court of Appeal. I thank you most sincerely.
Good afternoon, the Honorable Chief Justice, the Deputy Chief Justice, my lords and my lady, Justices of the Supreme Court. My name is Esther Angawa. I'm led by Mr. Nelson Harvey for the first to the fifth respondents. ETOPS, ETOPS. A few days ago, Mr. Harvey told me a plane cannot fly with one engine. I didn't take his word for it. He's not a pilot. So I conferred with Captain Wicks Rabach, a military army captain, and now a commercial airline captain for more than 10 years. He laughed, he said, yeah, it is true, a plane cannot fly on one engine for too long. It's a basic principle. It's ETOPS. Engines turn or passengers swim. Engines turn or passengers swim. That's the informal for extended range twin engine operational performance standards in airline lingo. In short, the ETOPS rule, currently 240 minutes in the US, is the amount of time that a twin-engine aircraft is allowed to fly along a flight path that is far from an adequate airport. So that if a two-engine aircraft chooses a flight path that goes beyond 240 minutes, and that's in exceptional circumstances, ordinarily it would be 180 minutes, that's 3 hours, there's a problem. Because should that plane lose one engine, it would not make it to the nearest airport and land safely. Engines turn or passengers swim. It is our submission that the IEBC is a twin-engine aircraft. Article 88, sub-article 5. The Commission shall exercise its powers and perform its functions in accordance with the Constitution and national legislation. The two engines. of the Commission. In the interest of time, my lords and my ladies, I know you have read and you will continue to read. I will not spend as much time on all the decisions that have been cited to you. But I would like us to use this basic airline principle to understand why this honorable court must interpret Article 88 and Article 250 subarticle 1 in the manner they were interpreted by the Superior Court and the High Court, and not in the manner suggested by the Commission. Composition of the IBC is at least 3, a maximum of 9. Composition defined in the Chambers Dictionary thus: composition, the act or act of composing. Compose, to form by putting together or being together, to set in order or at rest. The Constitution constitutes the Commission by giving a minimum of 3 and a maximum of 9. In compliance with Article 88(5), Parliament enacted legislation, the IBC Act, which the second engine set the specific composition of the Commission now at 7. The marginal note in the IBC Act speaks to composition and appointment. Quorum is relegated to the schedule. Had the drafters of the IBC Act and even the Constitution intended that the composition of the Commission be equated to its quorum, nothing would have stopped them from doing so in the Constitution or in the section that provided for the composition of the Commission in the IBC Act. This is the definition of quorum. The legal definition of quorum under the Black's Law Dictionary, I'm referring from the 9th edition. Quorum is defined thus: in parliamentary law, the minimum number of members, usually a majority of all the members, who must be present for a deliberative assembly to legally transact business. That is the definition of quorum. Now, what is the definition of majority? This is the definition of majority under the Black's Law Dictionary: the status of one who has attained the age of 18, the relevant definition being the second, a number that is more than half of a total, a group of more than 50%. A majority always refers to more than half of some defined or assumed set. So that if this court were to be convinced to follow the request by Professor Githumuigai, that where the paragraph on quorum is deleted, we must go back to the Constitution and rely only on the Constitution, our one engine for the Commission, because the second engine has failed. The Constitution sets a minimum of 3. He says, on behalf of the Commission, that they can go ahead and conduct business. Would quorum with a membership of 3 be 3? Based on the definition I have read to the court, absolutely not. A majority of all the members, being 3, would be 2 commissioners. Now, I would urge the court to read paragraph 77, 74 to 77 of the judgment of Justice Chacha Mwita when he was dealing with that conundrum, because then the quorum had been reduced to 3, and he was looking at those provisions that had reduced the quorum to 3, and saying then, with a membership of 3, because then the commission had only 3 members present, 4 having resigned. Would a legally binding decision of the commission be made by the majority, being 2 commissioners? And what effect would that have on the performance of the commission in its objects as stated in the Constitution and in the IBC Act, Section 3, subsection C, 3C, 31C? And the basis of the judge in holding that that amendment reducing quorum to 3 was unconstitutional, and a similar amendment to paragraph 7, which said that should the commission fail to reach a unanimous decision, then the decision of a majority of the members present and voting would bind the commission, which paragraph was also deleted. Meaning now that one engine has completely failed. Even if we were to say that the commission has 3 commissioners and is properly composed as according to the Constitution, what happens where a unanimous decision cannot be reached by the commission? Would the commission make legally binding decisions by its majority of 2? Justice Okwany saved the commission, qualifying the reason for doing so by creating a dichotomy between what she considered a policy issue and routine administrative issues that the commission that did not need commissioners to make decisions based upon. And that is the only reason that the judge act. Our twin engine is that, look, the commission, our twin engine aircraft has lost 1 engine and needs to get to the nearest airport to land. Otherwise, passengers swim. And so the court, in its wisdom then, allowed the commission the comfort to proceed, I believe, in the hope that the provisions of the IBC Act relating to replacement of the commissioners would be followed and the appointments would be made. That was not to happen. Now, my lords and my ladies, you have been told to ignore the fact that no appointment were made until over 4 years later. The plane crashed because the second engine, the Constitution, could not get the IBC to the nearest airport for landing. The IBC is now fully constituted. And it is my view that that is probably because of the determination by the High Court relating to the invalidation of the administrative procedures that it sought to rely on, which were made without it having all its commissioners on board. were that not to happen, who knows? We would be flying straight towards a general election with one engine nearly dying. I urge this court not to unsettle the holding of the Court of Appeal. And most importantly, because that holding relates to an invalidation of the administrative procedures, and if the court allows me, I would like to read it. This is what the holding of the High Court was. A declaration is hereby made that the administrative procedures for the verification of signatures in support of constitutional amendment referendum made by the Independent Electoral and Boundaries Commission are illegal, null, and void because they were made without quorum, in the absence of legal authority and in violation of Article 94 of the Constitution and Sections 5, 6, and 11 of the Statutory Instruments Act 2013. Uphold that declaration, my lords and my ladies. Because what is in challenge here is that declaration, not the decision of Justice Chacha Mwita. This is the holding of the Court of Appeal that touches on quorum. The Independent Electoral and Boundaries Commission does not have the requisite quorum for the purposes of carrying out its business relating to the conduct of the proposed referendum, including verification whether the initiative as submitted by the Building Bridges Secretariat is supported by the requisite number of registered voters in accordance with Article 257(4) of the Constitution. The IEBC has told you, if you cannot disturb the findings of quorum, if you cannot disturb the findings on quorum, then please circumscribe all the actions by the Commission prior to the making of the determination by the Court of Appeal. With all due respect, my ladies and my lords, we do not know what those actions are. Those actions have not been challenged before any court, at least not within our knowledge, and not within the court's knowledge. What actions are these? Where have they been challenged? And as His Lordship, Justice Tuyot said, this decision the declarations take effect at the date of judgment. I have indicated that what has been invalidated by the Court of Appeal on the basis of quorum is the administrative procedures and all the acts relating to the referendum. There is no basis upon which this court can protect certain actions that we haven't been told about. I urge you dismiss the appeals by the first and second appellant.
Thank you for your submissions. We'll move now to the next set of the respondents. The Third Way Alliance and all the persons who filed under Third Way Alliance. You recall yesterday, Philista Wakesho was given 15 minutes out of your time, so you have 45 minutes.
Thank you, Honorable Chief Justice. My name is Elias Mutuma. I appear for the 7th, 8th, and 9th respondents. I appear alongside Counsel Caroline Gerono. For the record, my lady, we have filed our submissions dated 9th of December 2021 and a case digest dated 21st of December 2021. I will be tackling 3 issues. One is the nature of a popular initiative and whether it is available for use by the President or the state. I'll also tackle the issue of public participation in as far as a popular initiative is concerned. My lady and my lords, I am persuaded to rely on the words of Shakespeare, who says that a rose by any other name shall still smell as sweet. I wish to add that a skunk in the same measure by any other name shall smell as bad. My lord, this initiative that has been brought to your attention has been branded a popular initiative. There is no name changing that is going to change the character of this initiative. It remains a skunk. It remains a presidential initiative as opposed to a popular initiative, and I'll demonstrate that as we proceed. It is our submissions, my lady and my lords, that the President is expressly prohibited from pursuing a popular initiative as a means to amend the Constitution. I will be supporting that argument with 2 grounds. One is the fact that sovereign power belongs to the people. This is captured under Article 1 of our Constitution, where the people can exercise that power directly or indirectly. A constitutional change process is a legislative duty, part of the sovereign power that the people can exercise. They either exercise that legislative duty directly or indirectly. In some instances, the people have donated that legislative duty to Parliament, and only Parliament, not to any other person. At no point have the people donated or delegated legislative power to the President. Constitution. Article 1 of the Constitution, again, is very clear that that power is exercised directly or indirectly. And my point is, the words used are either or, so that when the people exercise direct authority to legislate, then there is no other body that can exercise that power on their behalf. The words used are either or, not both. The provisions of Article 131, and I want to address my landed senior, Mr. Kamau Karori, do not include legislative duty. The President cannot seek refuge under Article 131. In fact, from 129, 130, 131, and 132 to purport to exercise executive authority in a manner to change the Constitution. Executive authority is the power to govern. It is not the power to legislate. So what Article 129 to 132 provides is for the President to govern. Legislating is not provided for under those articles. So he cannot act as a symbol of national unity and then purport to legislate. It would be usurping the role of the legislature. And by this I mean legislature, either Wanjiku herself or Parliament. There isn't any other person that can legislate. Indeed, if the president was to be allowed then to initiate a popular initiative or in any other way legislate, that would amount to acting ultra vires by going against the doctrine of separation of powers. Again, I emphasize that legislative must be distinguished from exercise of executive authority. And in case we have any doubt, my lady and my lords, as to what it means to legislate, a first-year law student knows that legislation is the process of enacting into law. And enacting is a process that begins at the point of framing or drafting the proposed law and will culminate with approval of that law. There are quite some processes in between. Therefore then, the person who enacts a law must be the person who frames a proposed law. So if the president frames, conceives the idea that we need to amend the law, then it is him who is enacting that law. When you look at Article 255 of our Constitution, and allow me to read, my lords and ladies, is that it provides as follows: a proposed amendment to this Constitution shall be enacted in accordance with Article 256 and 257. The word used is enacted, and approved in accordance with Clause 2 by a referendum. We therefore must interrogate, what does it mean to enact? So that when the Article 257 provides for the people to enact an amendment to the Constitution, it means, number one, they must be involved in the process of preparation and formulation of the proposed law. That is the first step. If they are not involved in the process of creation, formulation of that proposed law, then they are not involved in the process of enactment. The second phase of enactment is creation of awareness and consultation. In the case of Parliament, a bill is sponsored by a member of Parliament. It is introduced to the House through the first reading, and this is where members of Parliament get to interact with the proposed law. Now, in the event of a popular initiative, the question that we should ask ourselves is, did the people formulate the proposed amendment? Because you've been told by my learned friend, my good friend Jackson Awele and Arnold Oginga, that what preceded the collection of signatures did not matter. That it doesn't matter that the people did not formulate, did not prepare that bill. What matters is that we had 1 million signatures. That whoever initiated the process does not matter. It is inconsequential. I beg to differ. The third stage of enactment is content deliberation. In legislative terms, when it comes to Parliament, that is called the committee stage, where now the issues are brought before the members of the Parliament. They deliberate over the content with a view of persuading each other on whether we need to retain certain content or remove them. Now, at what point did the people, in exercise of their direct legislative duty under Article 257, undertake this process? You will not find that anywhere. Instead, what you're being told is that it is enough that the people will have an opportunity to vote at a referendum. And we have seen Article 255 talks about enactment and approve by way of a referendum. So how then are they exercising their legislative duty if they are not involved in these processes? The last process is the adoption of the proposed law or referendum, which happens even in Parliament. They must take a vote. Now let me pause and ask you a question, my ladies and my lords. Suppose a bill is brought to Parliament from God knows where, and it goes straight to the third reading, and members of Parliament are asked to vote for it. If they vote for that proposed law, will it become a proper law? Have they enacted that law? The answer is in the negative. That is what the appellants are telling you, that we should not worry about where that bill is coming from. We should not worry about the level of our participation. Ours is just to endorse. Then we will not have enacted that law. We will have endorsed but not enacted, contrary to section 255, 256, and 257. I make this submission because looking at the nature of a popular initiative, once IBC is presented with 1 million signatures and a draft bill, there is no chance of in any way altering the contents of that bill. It proceeds to the county assemblies, National Assembly, Parliament, that is the Senate, to the President, and back to IBC, which presents the bill to a referendum. So then, if it doesn't matter what happened before, I challenge my learned friends to tell me at what point will Wanjiku really propose any amendment or deliberate over the content, and that voice matters. It doesn't. Three questions that the court must ask itself to understand whether this is a popular initiative or not, or whether the president can do that. Did the people participate in the formulation? Was there any awareness of the contents? Was there any content deliberation? If no, then the court must be very clear that this is not a popular initiative. It is something different. Secondly, the second reason why the president cannot be allowed to initiate a popular initiative is under the social contract theory. Now, under this theory, my ladies and my lords, we have two parties. On one end, we have the governors, that is the government, and the governed, that is the people. So when the people elect their governors, they remain at one end of that contract. The governors are on the other end. The president, in this context, is the governor, the government. The people remain as the governed. Now, in a social contract theory, it is the people who create the form of government and the framework of governance. It is not the other way around. Then after doing that, they donate the power to the governor to govern them in accordance with what they have already formulated. Therefore, the president cannot now shift goals from being a governor and now start formulating a form of governance and subject it to the governed. That would be in breach of the social contract theory. Now, just to emphasize on that point, the Constitution under Article 131(2) provides for exactly that a president will be given a constitution, he will be given an already created governance framework and is required, number one, to respect, uphold, and safeguard that constitution. He is also supposed, under the same article, to safeguard the sovereignty of the republic. The republic is that he must recognize that these are the people who created this form of governance. These are the people who created this constitution. I have a duty to respect, to uphold, safeguard this constitution. So it is not for the president to create the constitution. It is not for the president to make the constitution or remake it. That is given to him once he enters into that social contract with the people. Now, purporting to remake a constitution will inevitably lead to him violating that duty under Article 131. Because under the social contract theory, the citizens are the right bearers and the governors are the duty bearers. So what the president has is a duty. What the people have is a right. His duty, as I've explained, is under Article 131 to safeguard that constitution. And just to ensure that the president understands this duty clearly, the third schedule of our constitution provides an oath of office, which states again as follows, that the president swears to obey, to preserve, protect, and defend the constitution. I'm only interested in one word, in those 5 words, to preserve. Ordinary English means to maintain in the original state. That is what he swears to do, to preserve the constitution. So upon the end of his term, and he has changed the constitution, will he have lived to his oath of office to preserve that constitution? It doesn't. He will have breached the constitution. Now, I find it a bit glaringly contradictory for the Attorney General to argue on one hand, and I think my learned friend Mr. Avi has touched on this, but I need to emphasize that indeed the president is an ordinary citizen for the purposes of enjoying rights under Article 19. Well, that is true, but then it is only true at the beginning when he is seeking to cross to the other floor, to become the governor, not the governed. So at that point, the president is at the same footing with every other citizen. But the moment he swears to defend the constitution, the moment he's given state authority, then he crosses over. And Article 24 now must come in to limit the exercise of his private rights. And the reason being, it is very difficult for you to distinguish between the president as a person and the president who occupies the office. Still, even if he says, I am a private citizen, state resources are still at his disposal. His political influence is still at his disposal for use. It is for that reason, and as a matter of necessity, that now Article 24 must come in and limit the exercise of his rights. And that is also confirmed by Article 143, because my learned friends cannot argue, on one hand, that indeed the president is an ordinary citizen, but still, under Article 143, he enjoys immunity. It is a contradiction. It must mean that Article 143 comes in because he's been elevated above the ordinary citizen. To answer a question that was posed by this bench as to whether the president initiated this initiative, I'll have 2 questions, my ladies and my lords. Number 1 is that this is an issue of fact, which was adequately canvassed at the High Court and the Court of Appeal. My understanding is that that is a settled issue that we cannot revisit at this stage. it is not in doubt because it is a factual issue. But if I was to answer that question, I would still go ahead and pause. Did we still witness the president's involvement even at the point of signature collection? And the answer is yes. So the president did not just stop at receiving the proposals. He went ahead and, number one, launched the signature collection at KICC. That is contained in our pleadings, and used state machinery to ensure that they collect their million signatures. On the question of public participation, I think there is no doubt, my ladies and my lords, that public participation has been entrenched in our Constitution and Article 10. The question is, what is the level and threshold of public participation in a process such as amending the Constitution? Now, to answer this question, we do not even need to go very far. I'll refer you, my ladies and my lords, at the preamble of our Constitution, which, with your permission, I'll read. And I'm looking at the last two bits of our preamble. In exercising our sovereign and inalienable right to determine the form of governance of our country, and having participated fully in the making of this Constitution, we adopt and enact and give this Constitution to ourselves and to our future generations. Now, I pick a few things from there. Number one is that the people are saying we have the sovereign power, the inalienable right to determine our form of governance. And for them to be able to exercise that, they are saying we are doing this after fully participating in the process of making this Constitution. That is the level of public participation. That is the threshold. Fully participated in enactment of the Constitution. Fully. And I started by explaining what enactment means. Formulation of the bill, creating awareness, content deliberation. That is what it means to fully participate. That is in the preamble of our Constitution. That is also captured under Article 1 of our Constitution. An argument has been advanced that then we are not making a constitution. We are merely amending a constitution. Therefore, we do not need to fully involve the people. But is that so? Are we really amending the constitution? The impugned bill that is before you, my ladies and my lords, is it an amendment? Or is it a process of making a constitution? Now, I want you to pause there, my ladies and my lords, and ask yourselves, if today we were in a constitutional moment, and by that I mean the moment we were in pre-2010, would we rush to Article 255, 256, and 257? The answer would be no. If we want to make a new constitution, because I do not doubt that we have a right to replace this constitution, just like we did in 2010. But if that moment comes, is that procedure provided for under 255, 256, and 257? The answer is no. Does it mean we cannot amend that? We cannot replace this constitution? Again, the answer is no. It only means that we have to go beyond the provisions of Article 255 to find the procedure elsewhere, because this constitution does not provide for its death. It does not provide for its replacement. There isn't any constitution in the world that provides for its replacement. There is no procedure. So therefore, when there is desire to amend, or rather to replace the constitution, you cannot find that procedure under Article 255. I started by arguing that this was not an amendment. And I will refer you to the Black's Law definition of an amendment. And my learned friend Harvey has mentioned a bit of it. I'm referring to the Black's Law Dictionary, the 9th edition, at page 94. An amendment is a right to correct or rectify. Now, the same Constitution has provided the meaning of repeal, which is what I'm talking about, replacement. And this is how it defines it. A repeal is done by specific declaration of a new statute or law. That is what we did in 2010. We declared a new statute, a new law, and did away with the one we had. That is called an express repeal. The same law dictionary now goes to the second definition of repeal, which is implied repeal, which has been defined to mean where the new law or the amended law brings about irreconcilable difference or conflicts between the old law and the new law, such that the new law cannot be mentioned to go hand in hand with the previous law. It is our submission that the bill before you was an implied repeal to our Constitution. Why am I saying so? This bill has some irreconcilable conflict with the form of governance that we have under the 2010 Constitution in terms of separation of power, in terms of the independence of the judiciary, in terms of the form of governance. So you cannot talk about this Constitution and still talk about interfering with separation of powers through an amendment. It is an implied repeal. It is for this reason that the High Court judges and the Court of Appeal judges identified that for you to alter this Constitution, for you to impliedly repeal this Constitution, you must go beyond 255. You must go outside what is provided for under this law. And that's why they came up with the 4 sequential stages. And that is based on our history. Civic education, public participation, which must entail collection of views, consultation through assembly debates, consultation and public discourse, and finally, a referendum. You have been told that this process begins at the point of signature collection. I beg to differ. There must be other processes that lead to the formulation of this bill. It is only through a 4 sequential process that we are able to achieve all the stages of enacting a law, because in this case, we are exercising legislative duty. On my last part, before I invite my learned friend to submit, because she's submitting on one issue, I'll pause and ask then, who has the duty? Who is the duty bearer to ensure there is public participation? Now, Article 88 of our Constitution provides for the responsibility of IBC, number 1, to conduct and supervise referenda and elections. So once IBC has been presented with their million signatures, and not just signatures, the law provides that those signatures must be in the company of a draft bill. It should ring in the mind of IBC that a process under Article 88 has begun. Their duty begins then. It does not come at the point of a referendum. You, my lords and my ladies, have argued before that election is a process. It's not an event. So once IBC is presented with that bill, and you will note that under Article 257, there is no time limit for IBC to satisfy itself, because there is a requirement that it should satisfy itself that the bill is in compliance with this article. There is no time limit. Then I submit, at that point, IEBC has a duty under Article 88 to ensure that before they formulate that policy, before they make that decision to forward the bill to county assemblies, that Article 10 has been complied with. They cannot run away from that responsibility. It is their duty. They must know at the end of the day, this is a bill capable of going to a referendum. So a process has begun. So then I submit that, just like in an election process, where IEBC is seized of the process right from nomination of candidates, it does not wait until 9th of August 2022 for it to say, now we are conducting an election. They begin their mandate as early as nomination of candidates. In the same way, once a bill is presented to them, it is upon them to ensure that there is adequate public participation. Because time only starts running once the bill is presented to the county assemblies with no option of any citizen's view being accommodated in the bill. I submit that that duty lies with IEBC to ensure that there is public participation once they receive that bill. In conclusion, therefore, I urge you, my lords and my ladies, just like the 5 justices of the High Court smelt a skunk, despite it being given a new name, just like the 7 justices of the Court of Appeal smelt it correctly and pronounced it to be a presidential initiative as opposed to a popular initiative, just like legal scholars have done, I urge you with tremendous respect, my lords and my ladies, to declare this as the same. It is a presidential initiative which has no place under Article 255, 256, and 257. I beg to rest and thank you so much. I invite my learned friend to address you on the question of multiple referendum questions. Thank you.
Good afternoon. Alongside Mr. Mutuma, as he has introduced me, for the 7th, 8th, and the 9th respondents. I am addressing this court on the issue of multiple referendum questions, which is an issue that was appealed against by my learned friend, Mr. Morara Omoke, and I would wish to confirm that I do associate myself fully with his submissions, both written and oral submissions. My lords and my ladies, this constitution is equated to a bridal gown that is due for customization before a tailor. And it is not the will of the bride that the gown be customized, but because of the dictates of how good she should look on her wedding day, the gown is presented for customization. And instead of affixing one color in line with the white gown or whichever color, be it silver or pearl, the tailor opts to patch the gown with different pieces of clothes with different colors. In short, the gown ceases to be a gown and it becomes absolutely something else. Why am I saying so? The element of hyper-amendability that this constitution seeks to prevent under Article 255, 256, and 257 is foreseeable or is expressed in the text of each and every article and clause. It is in singular form, an amendment, a bill, a general suggestion. My lords and my ladies, I draw your attention to the question that has been raised by Justice Ouko, on the holding of the Honorable Judge of the Court of Appeal, Justice Gatembu. And I pray that this Honorable Court will find and rectify that error and affirm that the decision of the Court of Appeal in as far as multiple referendum questions is concerned is settled. My lords and my ladies, Senior Counsel, the Honorable Attorney General Emeritus, Professor Githu Muigai, submitted that both the High Court and the Court of Appeal declared itself on a matter that was not ripe before it. I beg to differ by drawing the attention of this court to two incidences when the county assembly of Nandi, where I come from, and that of Kericho and Makueni sought advisory opinion on matters touching on Article 257(10) of the Constitution. And this honorable court directed the parties to seek direction from the High Court because it was not, as it said, it was not seized with a jurisdiction. I submit that the petitioners, that is Third Way Alliance, Miruru Waweru, and Dr. Angela Mwikali, in their petition, that is petition E400 of 2020, made an application for, not made an application, but sought a prayer that the court makes a declaration by the mandate conferred to it under Article 165(3)(d) on interpretation of constitutional questions to declare that proposal that the Constitution requires that all the specific proposed amendments to the Constitution be submitted as separate and distinct referendum questions to the people. I submit that that prayer is what amounted to the judgment of both the High Court and the Court of Appeal. And it was not a matter of ripeness, because the High Court did not have to wait for an action to happen for it to make a declaration as such. We submit that the submissions of the IEBC on that account are unfounded. And that the aspect of unripeness is settled. Further, Your Honor, my lords and my ladies, at the time of filing the petitions in the High Court, the IEBC was already seized with the Constitution of Kenya Amendment Bill 2020. As such, it had already given a template to one Dennis Waweru, as they call themselves, and Junet Mohammed, a template or a guideline on how they were going to obtain signatures from the registered voters. Further, upon receiving the signatures, it went ahead to verify, as it has admitted, and presented the bill to the county assemblies. As such, its role began running. So it was already seized with the constitutional mandate on preparation for any outcome. And we all know that these amendments, this bill, the impugned BBI bill, contained clauses, amendments that were touching on Article 255(1), the protected clauses. And as such, it would in one way or another end up in a referendum. IEBC was already seeking funding or allocation of funds from the Treasury, from Parliament, of 40 billion, if I may say. What does that mean? That it was anticipating to carry out a referendum. My lords and my ladies, the reason why it is important to affirm that or interpret that Article 257(10) of the Constitution implies that proposed amendments should be presented to the people of Kenya as separate and distinct. The referendum question should be separate and distinct, is as held by Justices Kiage, Gatembu, Nambuye, and Okwengu. The courts, both in the High Court and in the Court of Appeal, drew inferences from the judgment of Honorable Ochieng in the Titus Alila case. But the reason why it is important to separate those referendum questions is such that you do not throw the baby and the bathwater all at once. So that the people of Kenya have a choice to make, whether to pass those amendments that they deem fit and reject those amendments that they don't deem fit. In this context, we have an omnibus bill that is touching on 74 clauses of the, or more of the Constitution. As such, a common mwananchi, an illiterate village woman in Homa Bay County is unable to distinguish all those and make a conclusion that this bill is fit to pass as a constitution. And I drove this court to my first submission on protection of this constitution against dismemberment, against hyper-amendability. My lords and my ladies, I submit that the High Court and the Court of Appeal judges were right in holding that Article 257(10) should be interpreted as such that the proposed amendments to the Constitution be separate and distinct referendum questions. I refer the court to Section 49 and Section 51 of the Elections Act. And just so that I don't forget, the Court of Appeal held, and this is a ground that has not been appealed against, that there was no, at the time of submitting the BBI bill, the Constitution of Kenya Amendment Bill 2020, at the time of submitting to the IEBC and the Parliament, there was no legal framework guiding IEBC on how to carry out voter verification, and as well, by extension, public participation. So, as much as the law, the statute and the Elections Act touches on referendum, it is very specific on touching on questions, the referendum questions. That is Section 49. Section 49 Section 49(4) provides that the National Assembly may approve one or more questions for a referendum. So the element of separate and distinct referendum questions was foreseeable in the Constitution as well as the governing legislation, so that the IEBC cannot be deemed to be running away from its mandate to separate referendum questions, so that Mwananchi or Wanjiko is able to differentiate at any given time. As well, that at any given time, amendments to the Constitution should be singular. It should not cloud all the chapters of the Constitution and present it as though it is a single amendment. As such, I rest my case and I submit that this Honorable Court upholds or affirms the decision of the Court of Appeal and correct the error that is on the face of it. I beg to rest my case.
Thank you very much, Counsel. It is now almost 4:20. We will propose that we adjourn at this point. There are 3 parties remaining. That is the 11th and 12th, who are represented by Advocate Evans Oganda. Then there is the 24th, the respondent, Muslim for Human Rights, and the 79th, Kituo Sasheria. We'll hear them tomorrow morning at 9. We will.
Thank you. Sorry, Melody, for that interjection. In terms of the proper order, we anticipate some time donation from Muslims for Human Rights. So we will suggest that they go first. My name is Ongoya for the 11th and 12th respondents. Then their remaining time, they'll donate so that we're able to manage that time better. That we had discussed with them for the sake of donation of time, so that they don't donate in advance, which may embarrass them later.
Okay. Yes, so then we will start with the 24th respondents. We had allocated them 30 minutes.
Sorry again, Your Honor. When you gave the original directions,
Yes.
these were the only parties who got revised directions from the court,
Yes.
giving them 45 minutes. But in view of the subsequent direction yesterday,
Yes.
they therefore have their 1 hour.
They have 1 hour.
Thank you.
Okay, and then you have 30 minutes.
Yes, we have 30 minutes subject to the donation we'll get from them.
Okay. We'll follow that order. We'll begin tomorrow at 9 o'clock. Have a very nice evening.